Hello, everyone, and welcome to Uncivil Law. I hope you're having a good day today. And we are here with the decision that came down today from the 11th Circuit Court of Appeals in the case of In re Courtney Wild. Miss Wild is a victim of Jeffery Epstein, who you will remember purportedly hung himself in his cell in Manhattan recently. But lawsuits continue going on, including this one that was originally filed like 12 years ago. Well, we have a decision on this, and we're going to be reading it because I figure it's the least we can do to try to understand what happened. So, for those of you who may have forgotten, Jeffrey Epstein was the owner of Pedophile Island and Lolita Express and had a very nice mansion in New York who was given to him by the owner of Victoria's Secret's parent company for some reason and may have been a spy or international operative of some kind. And may still be alive for all I know. Because the whole thing is so weird that I don't put anything behind the realm of possibility. But we're going to be covering this case and see what it has to say. I hope you have a drink. I have an entire bottle of wine, which I'm probably going to be going through, so. This all stems from the 2007 plea agreement that Mr. Epstein reached with then U.S. Attorney Acosta, Jim Acosta. We remember him, right? And he got a very, 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 very generous plea deal. And Miss Wild wasn't notified, and she'd like to overturn the plea deal. The reason she wants to overturn the plea deal is because she wants to figure out who the associates, if any, of Mr. Epstein might be for, other legal purposes. So we're going to read this and figure out what it has to say. Good stuff. Here we go. This case, which is before us on a petition for a writ of mandamus, which means just an order to do something, mandate, arises out of a civil suit under the Crimes Victims' Right Act of 2004. Petitioner Courtney Wild is one of more than 30 women, girls really, who were victimized by notorious sex trafficker and child abuser Jeffrey Epstein. In her petition, Ms. Wild alleges that when the federal prosecutor secretly negotiated and entered into the non-prosecution agreement with Epstein in 2007, they violated her rights under the law, in particular her rights to confer with government lawyers and to be treated fairly by them. Despite our sympathy for Ms. Wild and others like her who have suffered unspeakable horror at Epstein's hands only to be left in the dark, and so it seems affirmatively misled by government lawyers, we find ourselves constrained to deny her petition. We hold that as the matters currently stand, which is to say, at least as the CVRA is currently written, the rights under the Act do not attach until criminal proceedings have been initiated against a defendant either by complaint, information, or indictment. So until there's some formal process, effectively, right? A complaint, information, or indictment, these would be examples of formal process, a formal start to a hearing. So as long as it's in some sort of investigation stage, it doesn't apply. So the U.S. attorney can reach a plea deal with someone despite never charging them. Okay. Because the government never filed charges or otherwise commenced criminal proceedings against Epstein, because the whole thing was a non-prosecution agreement. It wasn't even a plea deal. It was a non-prosecution agreement, right? So, because the government never filed charges or otherwise commenced a criminal proceeding against Epstein, the Criminal Victims' Rights Act was never triggered. It is not a result we like, but it is the result we think is required. Good deal. The facts underlying this case, as we understand them, are beyond scandalous. They tell a tale of national disgrace. Over the course of 8 years, between 1999 and 2007, well-heeled and well-connected financier Jeffrey Epstein, which, as others have pointed out, we don't have really any particular evidence of him ever engaging in any kind of trade with anyone. There's no records of any kind of trade with anyone. No one seems to have ever done business with him. No one seems to know how he got his money. Okay. And multiple co-conspirators sexually abused more than 30 minor girls, including the petitioner in Palm Beach, Florida, and elsewhere in the United States and abroad. Epstein paid his employees to find minor girls and deliver them to him, some as young as 14. Once Epstein had the girls, he either sexually abused them himself, gave them over to be abused by others, or both. Epstein, in turn, paid bounties to some of his victims to recruit other girls into the ring. Following a tip in 2005, the Palm Beach Department and FBI conducted a 2-year investigation of Epstein's conduct. After developing substantial incriminating evidence, the FBI referred the matter for prosecution to the U.S. Attorney for the Southern District of Florida, which is what you do, right? The FBI is the police force. They can arrest, but they don't prosecute. So this is normally what they do, right? They normally make a referral to the U.S. Attorney. Okay. Beginning in January of 2007, and over the course of the ensuing 8 months, Epstein's defense team engaged in extensive negotiations with federal prosecutors in an effort to avoid indictment. Why is Epstein getting this special treatment? Why not just indict? Who knows? At the same time, prosecutors were corresponding with Epstein's known victims. As early as March 2007, they sent letters advising each one that as a victim and or witness of a federal offense, you have a number of rights. As it would turn out, apparently not so much. The letters, which were distributed over the course of about 6 months, went on to enumerate the 8 Criminal Victim Right Act rights then in force, including, as particularly relevant here, the reasonable right to confer with the attorney for the government in this case, and the right to be treated with fairness and respect for victims' dignity and privacy. By May of 2007, government lawyers had completed both an 82-page prosecution memo and a 53-page draft indictment alleging that Epstein had engaged in numerous federal sex crimes. In July, Epstein's lawyer sent a detailed letter to prosecutors in an effort to convince them that, in fact, Epstein hadn't committed any federal offense. Okay. They seem to have plenty of evidence that he did, but okay. By September, the sides had engaged multiple drafts of what would become an infamous non-prosecution agreement. Pursuant to their eventual agreement, Epstein would plead guilty in Florida court, which is to say state court, to 2 state prostitution offenses, and in exchange, he and any co-conspirators, at least 4 of whom who have since been identified, would receive immunity from federal prosecution. So not only him, but any co-conspirators would get a waiver of any prosecution, 4 of whom have been identified, and others. They all get immunity. Why all this special treatment? Why not just indict? Why not just do the normal process? Why all this negotiation, and why all this writing a draft indictment? Why not just indict? It's what you normally would do. In 2008, Epstein pleaded guilty to state crimes and agreed, and sentenced to 18 months of imprisonment, which didn't really happen, 12 months of home confinement, and lifetime sex offender status, which didn't really happen either. The district court found that from the time the FBI began investigating Epstein until September the 24th, 2007, when the government formally executed the non-prosecution agreement with Epstein, federal prosecutors never conferred with the victims about the NPA, the non-prosecution agreement, or told the victims that such an agreement was under consideration. Worse, it appears that prosecutors worked hand in hand with Epstein's lawyers, or at the very least acceded to their requests to keep the non-prosecution agreement's existence and terms hidden from the victims. So we're not telling the victims that we're negotiating this or keeping them in the loop or anything like that. The non-prosecution agreement itself provides that the parties anticipate this agreement will not be made part of the public record. Okay. And further, if the United States receives a Freedom of Information Act request or any other compulsory process commanding disclosure of the agreement, it will provide notice to Epstein before making the disclosure. Moreover, at the same time the sides concluded the non-prosecution agreement, they began negotiating about what prosecutors could and couldn't tell victims about the agreement. This is way abnormal. Seemingly in deference to Epstein's lawyers' repeated requests, the government held off for nearly an entire year of notifying them about the non-prosecution agreement's existence. And to be clear, the government's efforts seem to have graduated from passive non-disclosure to, or at least close to, active misrepresentation. In January of 2008, for example, approximately 4 months after finalizing and executing the NPA, The government sent a letter to petitioner stating the Epstein case was currently under investigation, explaining that this can be a lengthy process, and requesting her continued patience while it conducted a thorough investigation. The government sent an identical letter to another victim in May of 2008, some 8 months after inking a non-prosecution agreement. If secrecy was the goal, it appears to have been achieved. There's no indication that any of Epstein's victims were informed about the non-prosecution agreement or the state charges until after he pleaded guilty. On the day that Epstein entered his guilty plea to the state charges in June of 2008, some, but by no means all, the victims were notified that the federal investigation had been concluded. But it wasn't until July 2008, during the course of this litigation, that the petitioner learned of the MPA's existence, and until August of 2008 that she finally obtained a copy. We are doubtlessly omitting many of the sad details of this shameful story. For our purposes, we need not discuss the particular of Epstein's crime, or the fact that national media essentially ignored for nearly a decade the jailing of a prominent financier for sex crimes against young adults. Today, the public facts of the case are well known. Epstein was eventually indicted on federal sex trafficking charges in the Southern District of New York, and in August 2019, while awaiting trial, he was found dead of an apparent suicide. Or so they say. In July 2008, petitioner brought suit against the United States District Court for the Southern District of Florida. So I just want you to fully comprehend that sentence that we just wrote there. In July 2008, this appeal that we're reading started from a lawsuit that was filed in July 2008. This appeal is from a lawsuit that was filed 12 years ago and is just getting around to being decided by the Court of Appeals. Which makes me wonder what the hell was going on in the district court, but that's where we are. In July 2008, petitioner brought suit in the United States District Court for the Southern District of Florida, styling her initial filing as an emergency victims petition for enforcement of the Criminal Victims' Rights Act. As the district court explained, because there was no criminal case pending at the time, no federal charges had been filed against Epstein or anyone else, petitioner filed her petition as a new matter, which the clerk docked as a civil action. So she couldn't respond to it as a criminal action or a part criminal action. So we're just going to dock it as a new civil matter, which, for lack of an alternative, why not? The petitioner alleged that she was a crime victim within the meaning of the CVRA, and that by keeping her in the dark about the dealings with Epstein, federal prosecutors have violated her rights under the law, in particular her right to confer with the attorney for the government in the case, and to be treated with fairness and dignity for her respect and privacy. Over the course of the ensuing decade, the district court issued a number of significant rulings. For our purposes, 3 of the court's orders are particularly important. Initially, in 2011, the district court addressed the threshold issue of whether the CVRA attaches before the government brings formal charges against the defendant. The court held that it does because the statutory language clearly contemplates pre-charge processes. As relevant here, the district court relied principally on 2 CVRA petitions in so holding. First, it pointed to 18 U.S.C. 3771C1, in which the parties have held that the Act's coverage petition. That subsection, of which more will be discussed later, states that officers and employees of the Department of Justice and other departments and agencies of the United States engaged in detection, investigation, or prosecution of crime shall make their best efforts to see that crime victims are notified of and accorded the rights of this subsection. The district court held that subsection C1's requirement that officials engage in detection or other investigation to afford victims the rights to the enumerated section surely contemplates the pre-charge application of the CVRA. So they're saying it should apply to stuff that happened before the charge, which would make sense, right? Second, the court pointed to subsection D3, which the parties here call the venue provision, which states that crime victim seeking to vindicate his or her rights must file a motion in either the district court in which the defendant is being prosecuted, or if no prosecution is underway, in the district court for the district in which the crime occurred, which also would indicate that it would apply if there is no criminal prosecution, right? If the district court reason the CVRAs may be enforced before prosecution is underway, then to avoid a strained reading of the statute, those rights must attach before a complaint or indict formally charges the defendant with a crime, which kind of makes sense. This is dealing with Epstein's 2007 plea agreement. So we're going way back in time. We're dealing with stuff 13 years old today. We're just deciding that. Finally, the district court cited In re Dean, in which the Fifth Circuit observed that, at least in the posture of this case before it, the court emphasized that it wasn't speculating on the applicability to other situations. The victim to the rights could confer with prosecutor applied pre-charge. Having determined that as a matter of law, the CVRA can apply before formal charges are applied, the district court here deferred to a ruling on whether the question of whether the prosecutors had violated the act until they could do additional discovery. Following another 8 years of litigation, for some reason, what were they doing for 8 years? The district court issued a pair of rulings that prompted the mandamus petition now before us. In February of 2019, the court found the government had infringed their rights. In particular, the court held federal prosecutors violated the act by entering into the non-prosecution agreement with Epstein without conferring with petitioner during negotiation and the signing. Had the petitioner been informed of the government's intention to forego federal prosecution of Epstein in deference to him pleading guilty to state charges, the district court emphasized, she could have conferred with the attorney for the government and provide input. The court concluded that it was precisely this type of communication between prosecutors and victims that was intended by the passage of the Crime Victims' Rights Act. Having found the CVRA violations, the court directed the parties, by which that included Epstein as an intervener, which gives him a right to intervene. So, like, she's suing and Epstein gets processed, even though she didn't originally, which is kind of an ironic touch. To brief the issue as to what remedy, if any, should be applied for this apparent violation. In response, petitioner proposed multiple remedies: rescission of the agreement, an injunction against further violations, an order scheduling a victim impact hearing and meeting between the victims and Alexander Acosta, the former United States Attorney for the Southern District of Florida, discovery of certain grand jury materials, records regarding prosecution decisions that enter into the agreement, and files concerning law enforcement investigations of Epstein, mandatory training for employees of the office, and sanctions, attorney's fees, and restitution. In August of 2019, while the court was considering the parties' briefing regarding remedies, Epstein died of apparent suicide. This provided another round of briefing on the issue of mootness, which I'm sure it did. In September of 2019, having considered the parties' briefing and impact of Epstein's death, the district court dismissed petitioner's suit, denying each of her requested remedies. In this order, the district court made a number of rulings. First, it held that Epstein's death mooted any claim regarding the MPA's continued validity, as he is no longer the subject of prosecution. Relatedly, the court held that it lacked jurisdiction to consider the claim regarding the validity of the MPA as it applied to Epstein's co-conspirators. Any opinion regarding that issue, the court concluded, would merely be advisory because the co-conspirators, as non-parties to the suit, couldn't be stopped from asserting the MPA's validity in a future prosecution. Nice. Second, the court denied petitioner's request for an injunction on the grounds she had failed to show a continuing present adverse effect or any real or immediate threat of future violation. Third, the court rejected petitioner's request for a victim impact hearing and meeting with Acosta on the grounds petitioner had already participated in an Epstein-related hearing in New York, that Epstein prosecutions had concluded, and the government had already agreed to confer with victims concerning any outgoing investigation relating to the co-conspirators, which, do we really think that's happening? And are they doing investigations? Probably not. Fourth, the court denied petitioner's discovery request for grand jury materials and investigative files. That would be pretty typical. Getting that kind of stuff would be pretty hard. Nice to have you, Leonard. Fifth, the court declined to order educational remedies as the government had already agreed to implement the CVRA training for employees of the United States District Attorney's Office. And finally, the court rejected petitioner's request for sanctions, fee, and restitution. Seeking a review of the district court's order refusing every remedy that she had sought, petitioner filed, as the CVRA directs, a petition for a writ of mandamus with this court. The government filed a brief in response, which it not only opposed petitioner's arguments on the merit, but also raised several threshold arguments concerning the scope of the CVRA and the circumstances in which the rights under the Act are judicially enforceable. In reply, petitioner contended, among other things, that failing to cross-appeal, the government waived its arguments about the CVRA's applicability and enforceability. All right, so let's just do a brief review of what we have discussed so far for those of you who are joining us late. In 2007, the Southern District of Florida reached a plea agreement with Jeffery Epstein that basically gave him a walk and gave him non-prosecution both to him and any co-conspirators in exchange for Epstein pleading guilty to some state charges, which happened. During the entire time they were negotiating the non-disclosure agreement or this non-prosecution agreement, and for a year after they inked the deal, the Southern District of Florida federal courts or federal prosecutor actively misled the victims by telling them that they were still investigating when they clearly weren't. All right. So sometime in 2008, a year after this non-prosecution agreement was reached, one of the victims here, the one that's at issue, found evidence of it and got a copy of it in 2008. She filed suit in 2008 seeking to undo the NPA, the non-prosecution agreement, because it was in violation of her rights under the Criminal Victims' Rights Act. She filed suit in 2008. Yeah. Then, fast forward to 11 years later, the district court is finally getting around to issuing remedies for a violation that it found, and then the guy kills himself. And then the district court says, well, we can't do anything because he's dead. So the whole thing's moot. And 12 years after she first filed suit, the Court of Appeals for the 11th Circuit is going to rule on whether or not she had any rights. That's where we are. That's where we are. Insert your own 12 years a slave joke at this point, I guess. Yeah, allegedly killed himself. Very good. The case presents a host of issues, many of first impression, which is just a technical term for meaning that we've never had to consider anything like this before. Which, fair enough. Before jumping in, we begin with an introductory summary of the Criminal Victims' Rights Act. Good. The CVRA is a compact statute, occupying but one section and only 2 pages of the U.S. Code. The entire act comprises just 6 subsections, the pertinent portions of which we will summarize briefly. The Act opens in subsection A with a catalog of the rights that federal law guarantees to crime victims. The Act separately defines the term crime victim to mean a person directly and proximately harmed as a result of a commission of federal offense, which, fair enough. The version of the CVRA in effect during the relevant issues here between 2006 and 2008 states as follows. The rights of crime victims. A crime victim has the following rights. The right to be reasonably protected from the accused. The right to be reasonably, accurately, and timely noticed of any public court proceeding or any parole proceeding involving the crime or of any release or escape of the accused. The right not to be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines the testimony by the victim would be materially altered if the victim heard other testimony at the proceeding. The right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any other parole proceeding. The right to reasonably confer with the attorney for the government in the case. The right to full and timely restitution is provided by law, which, is a little redundant because they already had that right because it's already being provided by law, but okay. The right to proceedings free from unreasonable delay. Once again, this was originally filed in 2008, so how are we doing there? Q squared gives me $2. This seems to be a miscarriage of justice, in my humble opinion. Well, if you mean the original plea agreement, I will agree, for sure. If you mean this decision, I don't know yet. I haven't gone that far. But we will read it and see the degree which we found it persuasive or not. But the original plea was a true travesty, yes. Subsection B, titled Rights Afforded, focuses on courts' responsibilities under the Act. It provides as relevant here that in any court proceeding involving any offense against any criminal victim, the court shall ensure the crime victim is afforded the rights described in subsection A, which I'll immediately take note are a little vague and a little loose. So, that's also a bit of a problem. Subsection C entails best efforts to afford rights imposes obligation on non-judicial actors, which would presumably be the U.S. Attorney. One of its constituent clauses, which we introduced earlier as a so-called coverage provision, states as follows. Officers and employees of the Department of Justice and other departments and agencies of the United States engaged in detection, investigation, or prosecution of crime shall make their best efforts to see that crime victims are notified of and accorded the rights described in this subsection. Subsection D addresses enforcement and limitations. Several subsection D3 provisions are relevant here. 1. The venue provision states the rights described in this subsection shall be asserted in the district court in which the defendant is being prosecuted for the crime, or if no prosecution is underway, the district court which the crime occurred, which presumably this is the right place under that section, right? Zachariah, in answer to your question why we're doing this, we're trying to undo the plea agreement to get to some of the co-conspirators is the reason why we're trying to undo this. That's the reason why, at least in part. Another provides that if the district court denied the relief sought, the movement may petition the court for a writ of mandamus. And as amended in 2015, and thus before petitioner sought review here, it goes on to clarify that in deciding a mandamus petition, the Court of Appeals shall apply ordinary standards of appellate review. Subsection D6 is also relevant in two respects. First, it states that nothing in this chapter shall be construed to authorize a cause of action for damages. Second, and separately, it emphasizes that nothing in this chapter shall be construed to impair the prosecutorial discretion of the Attorney General or any officer under the discretion. Finally, subsection F, we've already introduced subsection E, which defines the term crime victim, instructs the Attorney General to promulgate regulations to enforce these crime rights and ensure compliance. With that primer, we address the petitioner's case. Petitioner contends, and we've already explained, the undisputed facts show the federal prosecutors in the Southern District of Florida negotiated a secret non-prosecution agreement with Epstein. And from the time the FBI began investigating Epstein through the consummation of this secret non-prosecution agreement, the government never conferred with Epstein's victim about the agreement or even told them that such an agreement was under consideration. By keeping her and others in dark concerning Epstein's non-prosecution agreement, petitioner asserts the government violated the law. The unique circumstances of this case, and in particular the fact that Epstein was never charged in the Southern District of Florida, tee up what the district court correctly called the threshold question. I'm out of wine. I will pour myself another glass. Thank you for everyone here who is a part of the stream. As you can probably anticipate, this stream is going to be demonetized, I'm sure. So if you can contribute financially, it will be appreciated. Here's the threshold question. Does the CVRA apply in the period before the criminal proceedings are initiated, either by complaint, information, or indictment? If it does, then we must proceed to consider a cascade of logically subsequent questions, among them whether the act authorized the district court to rescind the non-prosecution agreement, both generally and more specifically as applied to the co-conspirators. Well, I don't know why they're drinking. I'm drinking a generic red. I'm drinking just yellowtail red. Whether petitioners were entitled to discovery of certain grand jury materials, DOJ records relating to the non-prosecution, and FBI files. Whether petitioner participation in the victim impact hearing in New York effectively moots her request, I don't think it really does. And whether federal law entitles petitioner to recovery of attorney's fees. If by contrast the CVRA does not apply, then our inquiry is at an end. Fair enough. Whether the CVRA applies prior to the initiation of criminal proceedings is not just a threshold question, but also a question of first impression, which is again to say there's no case law on point. Question of first impression is just a technical term. It just means there's no case law. The Fifth Circuit has stated, albeit in dictum, which is to say non-binding, and without meaningful explanation, and similarly without the benefit of adversarial testing, the Act can comply before criminal proceedings begin. The Sixth Circuit has deemed it uncertain whether the protections apply prior to the filing of charges. The district courts that have considered the question are divided. As already explained, the district court here concluded the CVRA can apply before the initiation of criminal proceedings, pre-charge for short, and accordingly petitioner enjoy the protections of the Act during the period. Zachariah asks, is dicta ever labeled as obiter dicta? I very, very rarely is it labeled. How do you know what's dicta? Good question. Training and experience. But the long story short is that dicta is anything that's not necessary to decide the case. So anything that is not necessary to it. So off the point musings, right? Stuff that's not necessary is technically dicta. But yeah. In particular, petitioner asserts in these proceedings the government violated her reasonable right to confer with the lead prosecutor and a right to be treated with fairness, neither of which, she said, is limited by terms to the post-charge phase of criminal proceedings. In support of her position, the CVR rights can apply before criminal proceedings begin. Petitioner points, as does the district court, to Section 3771C1, which refers to federal government agencies engaged in detection and investigation of crime, which certainly suggests prior to prosecution, right? And to 377D3, which, in specifying venue where it should be relieved, refers to the eventuality that no prosecution is underway, which also seems to be pre-charge. So far, on initial reading, I think her point is the better point. It seems logical. So what is the argument to the contrary? This interpretation of the CVRA that petitioner advances and district court adopted is not implausible. The CVR could be read to apply pre-charge. Seems logical. We conclude, though, reluctantly, especially given the mistreatment that petitioner seems to have suffered, the act is neither best nor naturally read this way. For reasons we will explain, we hold the text and structure, the historical context, and prosecution discretion principles that it was designed to safeguard, and which we think petitioner's interpretation would compromise. I don't know that would compromise those principles, but whatever. Demonstrate that its protections apply only after the initiation of criminal proceedings. If Congress believes that we misinterpret the CVRA, or that for that matter even believes that we've correctly interpreted the statute as currently written but the scope should be expanded, then it should amend to make clear. $2 from Greg Polanski. Thank you for the super chat. Wait, is this the individual that killed himself? It sure is. Q squared. Long story short, UL would buy this merch shirt. Fantastic. We might get there. Yes. But yes, this is the guy that allegedly killed himself. We are now debating events that occurred in 2008 because it's taken 12 years to get to appeal. Fun. And thank you both for the super chats. It helps. In construing the statute, we begin, as we must, with a careful examination of the text. Yep. Look into the particular statutory language at issue as well as the language to design the statute as a whole. On balance, we conclude the Act's terms, including the provisions on which petitioner relies, demonstrate its protections apply only after the commencement of criminal proceedings. We begin where the petitioner does, with the catalog of rights, quoted in full above, that the CVRA guarantees to crime victims. Petitioner relies chiefly on the guarantee of the reasonable right to confer with the attorney for the government in this case, and the guarantee of the right to be treated with fairness. She contends that by failing to inform her, at worst affirmatively misleading her about ongoing negotiations, the government violated both these provisions. We will address these subsections in due course, but because statutory construction is a holistic endeavor, which means you do it as a whole, right? You do it in whole. You interpret the whole thing together, right? So it's not one piece at a time. You try to do it as an entire thing when you can, right? Individual provisions can govern, but you look to the entire whole. You look to the whole context. That's holistic, right? And because a provision that may seem ambiguous in isolation is also clarified by the remainder of the scheme. Fair enough, We do look to the entire thing as a whole, We can look to particular provisions, but we also look to the whole context. Fair enough. In the main, anyway, and there isn't any real dispute about this, the CVRA's enumeration seems to focus on post-charge phase of criminal prosecution, and in particular ensuring that crime victims have notice of and opportunity to be heard of in the pending criminal proceeding. Indeed, 6 of the rights here, all except for those listed, either expressly refer to or necessarily presuppose the existence of ongoing proceedings. Subsections 2, 3, 4, and 7 leave no doubt. Okay. Whatsoever, all of them by their plain terms, to proceedings, public proceedings, or public court proceedings. Not surprisingly, there seems to be general agreement that these proceeding rights focus only after the filing of the complaint or criminal charges. Subsections 1 and 6 are not quite as clear, but they too are best as understood as specifying rights that only attach to criminal proceedings after they've begun. Subsection 1 guarantees a crime victim's right to protection from the accused. Okay. Both in ordinary spoken English and as a legal term of art, the word accused refers to someone to whom criminal proceedings have been commenced. That's fair enough. Subsection A6, which guarantees a rights victim to full and timely restitution, likewise presupposes initiation and perhaps maturation or even conclusion of proceedings. Also, I think the entire subsection is redundant because it says your rights as afforded by law, which is like, what's the point of saying it? Because you already have them, because they've already been afforded by law. So the whole thing is a little bit weird. Black's Law Dictionary, the sovereign citizen's favorite dictionary, for instance, defines the terms restitution in relevant part to mean compensation for loss, especially full or partial compensation, paid by a criminal to a victim, not awarded in a civil trial for tort, but ordinarily as part of a criminal sentence or as a condition for probation. Yeah. So it seems to us the rights enumerated in subsections 1, 2, 3, 4, 6, and 7 are properly understood as only applying after the initiation of criminal proceedings. And again, petitioner doesn't really contend otherwise. Instead, she focuses on subsections 5 and 8, which she said are framed broadly enough that they can be understood to apply pre-charge. Let's take a closer look. Subsection A5 guarantees a crime victim the right to reasonably confer with the attorney for the government in the case. Petitioner and lead counsel, in his academic writings, emphasize the provision refers to the attorney's handling of the case rather than the charges. Okay. And they assert the term case can refer to both a judicial case before a court and an investigative case pursued by a law enforcement officer. Fair enough. Although it's true, at least in the abstract, the term case can mean anything, in legal parlance, the judicial case connotation is undoubtedly primary. Moreover, in any event, two contextual considerations convince us. As used in term A5, the term case refers to ongoing judicial proceeding, not a law enforcement investigation. First, the Supreme Court has held that in a criminal context, a case does not encompass the entirety of criminal investigation process, but rather, at the very least, requires us to initiate legal proceedings. Yeah, I'm very sorry about the itching in my face thing. It's because I have this light. I have this key light to keep me well illuminated. It makes me look good, but unfortunately my eyes are very, very photosensitive. As a result, if I'm not wearing any glasses or anything, it makes my nose itch, among other problems. So there's really nothing I can do to stop that, unfortunately, except turn off the light, which would be like not great because then I'd be in the dark. So we do what we can. Yeah. And, the light is pretty good. It makes me look really nice. So, it's worth it. It's not it. Well, I want to be lit up. I don't know if it's a vanity light so much as you are able to see me. Without the light, you wouldn't be able to see me. So, I don't know if it's a vanity light so much as you can actually see me because it's pretty dark in here. It's nighttime. Notably, even in so holding, the court drew on a long-standing tradition, now citing a 150-year-old decision in Plea versus United States for the proposition the word case is synonymous with the word cause and means for producing in court or suit or action. Yeah, I tend to agree with Zachariah. The facial expressions are a big part of it. Yeah. Secondly and subsequently, Section A5 refers to not just the case, but more particularly the attorney for the government in the case. While undoubtedly true the government lawyers may be involved in criminal proceedings pre-charge, the provisions reference to a single specific individual, the attorney for the government, indicates a conferral right attaches only after proceedings have begun, at which point a particular person will presumably be more readily identifiable. Fair enough. Yeah, fair enough. By the same token, there will surely be many criminal investigations to which no lawyers have yet been assigned, let alone a single identifiable government attorney. That's true. Especially in the formative stages of investigation, there's no attorney involved. It's only much later that the attorney usually gets involved. Usually after the FBI is completely done, but fair enough. Accordingly, as petitioner asserts, subsection A5 was intended to apply pre-charge. It makes little sense that Congress would tether it right to a single government lawyer. Okay, this reading kind of makes sense. I see where the court is going with its logic. On balance, therefore, and particularly in the light of the subsections 1, 2, 3, 4, 6, and 7, all of which clearly apply only after the initiation of criminal proceedings, we conclude that the 5 right does not attach to pre-charge investigative phase, where A5 is best understood as guaranteeing a crime victim's right to consult with a lead prosecutor, the attorney for the government, in a pending prosecution that is the case. Yeah. Petitioner also relies, although more obliquely, on subsection A8, which vaguely guarantees a crime victim's right to be treated with fairness and with respect to dignity and privacy. It's certainly true, and this fair treatment right has no inherent temporal limitation. On its face, it could be applied pre-charge, post-charge, or for that matter, even post-conviction. Which, some of these things are clearly post-conviction, because didn't some of these things talk about parole and things like and escape and things like that? So some of these things are post-conviction. So those, that seemed to be in some of the language talked about the parole hearings and things like that. That's you can't really have a parole hearing before you're convicted, right? It's certainly, yeah. But even well-established canons of interpretation require us to interpret subsection A8's right to fair treatment by reference to the subsections that precede it. Because the rights enumerated in sections 1 through 7 are best understood as only applying after the initiation of criminal proceedings, subsection A8's guarantee of fairness is too. While the Supreme Court recently said in applying a Noricur Ascatus, the well-worn Latin phrase that tells us statutory words are often known by the company they keep, apply here as well. You interpret things in context. Yeah. In 3771A, we find both in the presence of the company suggests limitation and absence of the company suggests breadth. Taken as a whole, we conclude the catalog of rights specified in 3771A are best read as only applying after the initiation of criminal proceedings. Okay, that kind of makes sense, right? We got 8 of these rights. These seem to be talking about the trial. So the ones that are ambiguous also probably talking about the trial. It's all contemporaneous with it. And the logic of it makes sense. Okay, I understand. We are forfeited in the conclusion that by only 2 provisions of the Act that speak directly to judicial enforcement of rights. Fortified, sorry. It's like I misread that. Let me read it again. We are fortified that in that conclusion by the only 2 provisions of the Act that speak directly to judicial enforcement. The first is 3771B, rights afforded. At oral argument, petitioner's counsel invokes section B1 affirmatively, noting with emphasis its directive that the court shall ensure that a crime victim is afforded rights enumerated by the section. True, but that's only part of the story. In its entirety, subsection B1 reads as follows. In any court proceeding involving any offense against a crime victim, the court shall ensure. By its plain terms, then, B1 empowers courts to enforce rights only during the proceedings, of which there were none here. Hard to disagree with that. That one is pretty clear on its face. I'll have to give that one to the majority. The second is 3771D, which specifies and strictly circumscribes the procedural mechanisms by which an alleged victim must assert and seek to enforce their rights. 2 related points are worth making. As an initial matter, the Act clearly indicates that Congress did not intend to authorize private individuals to initiate standalone suits or actions outside the confines of an existing criminal proceeding to enforce their rights. Quite the contrary, in fact. Section D6, no cause of action. It expressly states that nothing in this chapter shall be construed to authorize a cause of action for damages. That is not quite right, because a cause of action for damages I would interpret as monetary damages. That's how I'd interpret damages. So nothing gives you a right to money. That's why I interpret as a right to damages, right? But a right to other kinds of proceedings, injunctions or writs or that kind of thing. I don't agree with that one. So that's one where I don't agree with the court. To say that you don't have a cause of action for damages is not to say that you don't have a cause of action for non-damages, equitable remedies, for example. Instead, and this is point 2, subsection D3 specifies the victim must assert his or her rights in a motion for relief filed by the district court and requires the court to consider that motion promptly. As commonly understood, a motion is a request filed with the court context of an ongoing judicial proceeding, not a vehicle for launching a new and freestanding piece of legislation. Interesting. I don't know, because if you were filing for a writ of summary, if you're filing for a writ of mandamus in the abstract, you could file a new proceedings, right? So that doesn't quite follow to me either. A TRO is a temporary restraining order. The facts that the Criminal Victims' Right Act does not sanction freestanding suits and does prescribe mild mid-proceedings motions combined, especially in conjunction with subsection A enumeration, to indicate the Act's protections apply only after the initiation of criminal proceedings. In fairness, petitioner is not without her own textual arguments. In urging us to hold the rights, only some of them apply before the initiation proceedings, she relies principally on two subsections, which the parties call coverage and venue. I agree. TRO would be a form. Yeah, exactly. A TRO would be an example of a non-monetary relief. Yeah, I'm on board. Yeah, that would be an example. Yeah, that's a good example too. Yeah. Petitioner first points to C1, the coverage provision, which, as already explained, states that officers and employees of the Department of Justice and other departments and agencies of the United States engaged in the detection, investigation, or prosecution of crime shall make their best efforts to see that crime victims are notified of and accorded the rights described in the subsection. From the premise, the Criminal Victims' Right Act applies to detection or investigation of crimes. Petitioner reasons to the conclusion, which the District Court adopted, that the Act's drafter surely contemplated pre-charge application. We disagree for two reasons. First, understood in proper context, it seems clear to us that C1 is a to whom provision, not a when provision. That is, it clarifies that CVRAs extend beyond officers and employees of the Department of Justice to include other agencies. Okay, fine. Those agencies, like the DOJ, must make their best efforts to ensure they afford these rights. Section C1 doesn't expressly speak to when CVRA rights attach, which, again, like the fact that we're talking about these agencies other than DOJ is somewhat indicative that it doesn't just have to be when proceedings start, because DOJ does all criminal proceedings. DOJ does all criminal proceedings, regardless of where they come from, right? IRS, ICE, if it's criminal, it's the DOJ doing it, right? DOJ does all the criminal stuff. Everyone else does referrals. So, like, if they only attached after the thing was filed, it would make little sense to talk about obligations to ICE, because what would that even mean? Because DOJ is the one handling the case, so it wouldn't make any sense. The very fact that we're talking about obligations to the IRS or ICE or anyone else suggests, at least in my mind, it's suggestive of pre-filing, because those are the only time that those agencies would have any kind of jurisdiction. Once it's handed over to the U.S. Attorney has jurisdiction over the case. So, like, the very fact that we're talking about the immigration having the obligation to give rights, means it's a pre-enforcement proceeding of some kind. I mean, that's what sees me. Government employees who are involved in all three of the reference phases are necessarily involved post-charge. No, see, that's where I'm going to disagree with you. ICE, TSA, they're not necessarily involved post-charge. They can be involved pre-charge. They can be involved very pre-charge. So I don't quite follow that one. And the DOJ is not necessarily involved post-charge either. The DOJ is involved pre-charge, as they were here. This was the DOJ. This was the U.S. Attorney for the Southern District. He was involved pre-charge. So it's belied by the facts of this case. The government employees, whether DOJ are involved in all three of these reference phases, are necessarily involved post-charge. I don't quite see that, right? And that doesn't make sense. Section C1 simply makes clear the Act reaches beyond prosecutors and DOJ to reach other actors, which again doesn't really make sense if we're only talking about post-charge, because those other actors wouldn't have any real role post-charge, right? Second, and more importantly, petitioner's reliance on C1 proves entirely too much. If, as petitioner thinks, C1 shows that rights apply to a detection investigation, there's no meaningful basis, at least no meaningful textual basis, for limiting the Act's application in the MPA's context. This is a better argument. To the contrary, on petitioner's reading, C1 would, to cite just a few examples, require law enforcement to confer with victims, subsequent only to a squishy reasonableness limitation, before conducting raids, seeking a warrant, making an arrest, interviewing witnesses, convening a lineup, or conducting an interrogation. That's a little bit of a fair point. It does prove too much. So that's a much better argument. Absent a much clearer indication, we cannot assume that Congress intended such a jarring result. Presumably, sensing the slipperiness of their petitioner and counsel have said the courts can simply draw a line farther downstream when, for example, as counsel put it, oral argument investigation has matured to the point where the prosecutions are negotiating with defense attorneys and signing agreements. At that point, at least, a conferral right exists under the section. That is a line to be sure, and a line that happens to capture this case, but has no footing whatsoever in the detection or investigation language. That's a fair point. As tempting as it might be to do so, especially on the facts before us, we cannot rewrite or arbitrarily circumcise the Act's text to make it fit the theory. Fair point. Fair point. For these reasons, we cannot accept petitioner's contention. The C1 demonstrates that the Criminal Victims' Rights Act applies before the initiation proceedings. Petitioner is on a slightly stronger footing, we think, in pointing to the venue provisions. In relevant part, that provision states, the rights described in the section shall be asserted in district court in which a defendant is being prosecuted for a crime, or, if no prosecution is underway, in the district court in which the crime occurred. Petitioner contends, and the district court agreed, that no prosecution is underway clause must mean that rights may be enforced before a prosecution is underway. I tend to agree with that. And accordingly, those rights must attach before complaint or indictment. Petitioner's interpretation is not implausible. That provision could be read to mean that CVRA rights attach before commencement proceedings, but it isn't necessary either. What's the alternative? Hopefully they'll get to that. And like the remainder of the Act's text and practical implication, the details of which we explore below, we're reluctant to adopt it, or at least to invest it with the significance the petitioner does. There are, we think, at least two alternative ways of understanding the statute. Perhaps most obviously, it could be read to apply the period of time between the initiation proceedings, which may occur as early as the filing of the criminal proceedings, and the levying of formal charges. The word prosecution, on which D3 pivots, is a legal term of art. In relevant part, it refers to the initiation and continuation of a criminal suit, a process of exhibiting formal charges against an offender before the legal tribunal, and pursuing them to final judgment on behalf of the state or government, as by indictment or information. Moreover, the law is clear, at least for Sixth Amendment right to counsel purposes, the prosecution does not begin with the criminal filing. Rather, the Sixth Amendment right does not attach because prosecution doesn't begin until, at the earliest, the suspect's initial appearance before the judicial officer. All of which is to say, if petitioner and district court are correct that no prosecution underway meant the rights apply before formal charges are filed, they may yet be incorrect as when those rights should be understood to attach to the pre-criminal investigation. Okay, so no prosecution's underway. So they're going to try to slice it at the difference between like the indictment being filed or something, as like the prosecution isn't underway, but the prosecution is underway when the indictment is filed. So are they going to try to slice it? Are they going to try to slice it between when the indictment or information is filed versus like the first appearance from the defendant? So that's how they're going to slice it. So they're going to say that, that as soon as the indictment is filed, but before the defendant first appears, that's the period we're talking about, because it's a pretty narrow period. I mean, normally you're talking about like, same day, next day, 2 days, 3 days, something in that neighborhood, right? So if the only period that this is talking about is the period before prosecution, is the period after indictment or after information, but before the criminal first makes his first appearance, you're talking about a pretty thin time window. So that's what they're going to try to squeeze this into, is that time window. Okay. Section D3 can be read sensibly enough and to give the victim's right to confer with prosecutors between the filing of the criminal complaint and the appearance before the judge. That's exactly what they're going to do. That's exactly what they're going to do. So they're going to slice it between the time of the filing of the criminal complaint, the time of the indictment, the time of the information, versus the first appearance from the judge. That's cutting it pretty thin. It's cutting it pretty thin. I mean, again, normally the period between indictment and the periods before first appearance before a judge is pretty thin, because you have to do like bail hearings and stuff like that. So like, we're talking about next day, 2 days, 3 days in a lot of cases. It's pretty thin. So, okay. Is a plea negotiation a judicial offer? I don't know what you mean by judicial offer. Um, a plea negotiation is a negotiation between the defendant and the prosecution. It's not an offer from the judiciary. It can be refused by the judiciary, but it's not an offer from the judiciary. So I'm not quite sure what you mean by your question. Alternatively, subsection D3 could be interpreted to refer the period after prosecution has run its court, resulting in a final judgment. Petitioner and district court read the no prosecution is underway clause to say in effect no prosecution is yet underway, thereby necessarily pointing the period before the prosecution's commencement. But subsection D3 is temporally agnostic. On its face, it could just as easily mean that no prosecution is still underway. No one doubts, for example, a victim could file a post-judgment motion alleging the victim has violated their rights and ask the court to reopen the plea or sentence. Moreover, petitioner's broad reading of D3 suffers from the same slippery slope problems that plague her reading of C1. To say, as petitioner does, and as the district court did, that D3 indicates the rights must attach before a complaint or indictment formally charges the defendant tells us nothing how long before. That's a fair point. It's not inherently constrained. Yeah, that is a fair point. Again, must petitioners consult with victims before they conduct a raid, seek a warrant, or conduct an interrogation? That seems exceedingly unlikely. As we explained, petitioner understandably wants to craft a rule that will cover this case without opening floodgates to those possibilities simply by reference to some sort of once the investigation has matured criterion. That criterion has no basis in text. That's very fair. That's very fair, and I'm leaning much more to this opinion because this is a very textualist, very non-intent opinion. It's not looking to the purpose of the statute. It's not looking to the intent of the statute. It's looking to the plain text words, right? So this appeals to me as a textualist, and this rationale appeals to my leaning. So this is pretty interesting, yeah. A plea does have to be accepted by a judge. That's true. There was no plea here. There was just a non-prosecution agreement. So there was never a case in federal court. There was a case in state court where a plea was accepted, but that's not neither here nor there. Must the Attorney General actually be an attorney? I don't know. I don't know the answer to the question. Presumably, but I don't know. I haven't read the relevant statutes. I don't know. It'd be pretty weird if they weren't, but I don't know the answer to that question. Yeah. For all these reasons, we conclude the text is best read as applying only after the commencement of proceedings, whether by complaint, information, or indictment. Okay. I'd just like to thank the 52 of you who are currently watching this stream. I appreciate having an audience. I appreciate that you guys are interested in the subject matter. I hope I'm covering it, pretty thoroughly. I hope I'm explaining things as I go along. I'm trying to explain things where I think they need to be explained. But of course, my understanding of what needs to be explained may not be yours. But I'm trying to be helpful in trying to understand this as I try to understand it myself and try to understand it against principles. So I want to thank you for being here as part of the journey. We're on page 37, where you got some length to go. What is a complaint in this context? A complaint is any legal proceedings filed by anybody, whether it's criminal or civil. It's a complaint. Yeah. For that matter, although it's a little unusual, the court did once use the language here to refer to the criminal proceeding as a suit. So normally when you think of a lawsuit, you think civil. But strictly speaking, the government is suing for criminal prosecution too. We don't normally use the word sue in that context, but it is a suit. It's a criminal suit, but the court did refer to it once either. So a complaint is just any filing by anyone against anyone else in court. A suit is a suit is the same thing as a complaint. So yeah, there you go. The historical context in which the CVRA was enacted informs what this was indicates. Namely, it was not meant to apply prior to the institution of criminal proceedings. Congress enacted the law as a backdrop against another victims' rights statute, the Victim Right and Restitution Act. The CVR repealed or replaced some parts of that act, but left others intact. I mean, the Zachariah, who says the complaint against terminology is a bad name. I mean, the complaint goes back, way back, way back. The word sue in this context goes back like, old school Latin. I mean, it goes back a couple thousand years. You can even use the word sue in the context of war. Have you never heard the phrase sue for peace? I've never heard that phrase, sue for peace. So the idea of a suit is just a seeking of a remedy. So that word goes back to ancient Rome, man. I mean, it's old school, man. Yeah. That section opens with a phrase the CVR repeats, noting that applies to government agencies engaged in detection, investigation, or prosecution. Although, unlike the CVRA, though, the VVRA directs the head of each agency to designate individuals who are responsible for identifying the victims. The Victims' Right Act goes on to state, at the earliest opportunity after detection of a crime, at which it may be done without interfering with the investigation, a responsible officer shall identify the victims and inform victims of their right to receive services. By referring to the period immediately following the detection of crime and existence of an ongoing investigation, the VRRA clearly extends victim right notices to pre-charge phase. Fair enough. The VRAA is similarly explicit when it describes sorts of services to which victims are entitled. Following subsection A's directions, subsection C marches methodically and roughly chronologically through various stages of the criminal detection process. Section C1 states, for instance, the responsible officer shall, presumably immediately in the aftermath of the crime commission, and thus by definition before charges are filed, inform the victim when she can receive emergency medical and social services. Yeah. Subsection C2 then responds that the responsible officer shall ensure victim receive responsible protection from the offender, not the accused, as in the CVRA, but suspected offender. I do like the juxtaposition of the different language. I do like that, where the court is taking note that language is being used by one court and not another, and showing the reasons why, one is interpreted the way as the other. Yeah. I'm not Leonard. I'm not Leonard. Yeah, you declare total authority. Yeah, I covered that earlier. No, President Trump does not have total authority. I actually do believe in federalism. I actually do believe in state rights. I actually do believe in the 10th Amendment. No. No. Continuing, subsection C3 states the officer shall provide the notice of, among other things, the status of the investigation and the arrest of suspected offenders, both of which refer to pre-charge events. It's not until subsection C3C, which refers to the filing of charges, the VRA's focus conspicuously shifts to charges, trials, hearings, and proceedings. Yeah, fair enough. You assume dog whistles was it state rights was a dog whistle? Yeah, no, it's a principled view of at least for me, it's a principled view of federalism, right? That the United States, this is off topic, but what the hell, right? The United States are states united. In the context of the word states, we're referring to like states in the same sense of nation states, right? But they're states united. So they are states with sovereignty that have given some of that to a national government and only some of it. So we talk about enumerated powers, we talk about limited federal government, we talk about police powers of the states, and so forth and so on. So like we try to apply these principles consistently. And so like I don't, Trump on the whole has governed more conservatively than I would have expected. But when he said, I have, what did he say? Unquestioned or absolute or whatever the adjective in the sentence was, when I have absolute power, I'm like, no, none of those things, no. The VRA's provisions about when Congress indisputably knew it, framed, and enacted demonstrate that when Congress wants to enact pre-charge, it knows how to do so, and how to do so expressly. The fact that CVRA contains no similar language counts heavily against the interpretation, which we call entire family of interpretive canons. Fair enough, they're trying to interpret one statute in light of another statute. They're trying to interpret some language in light of another statute. Now, we're talking about two statutes that were passed at the same time, apparently, or contemporaneously enough, right? So it makes sense to look at the language that was used in one and the other. And we've seen this also in the context of the Title VII of the Employment Act versus Title IX of the Education Act, which both prohibit discrimination against sex, one in the context of employment and one in the context of education, right? But they both are, and we're seeing courts interpret one in light of the other because they use similar language. So it's not at all uncommon to see companion statutes interpreted, in light of one or the other. And we say, well, these are passed by the same Congress at the same time. They deal with roughly similar subject matter, right? Victim rights, mandatory rights for victims, that kind of thing. So it's similar in purpose in the broad sense, right? The part of a package deal. We can look at language of one and language of the other, interpret one in light of the other, because Congress knew how to use particular words in one. So if it was using these particular words in one and different language in another that might have something different in mind, these are not invalid tools. So I actually do like this parallel construction a lot better for me personally than when I was looking at just the statute by itself. Because the statute by itself, I was like, I don't know, some of the stuff is a little bit weird. But this parallel construction makes sense, because we're looking at one Congress passing both statutes. They both are dealing with crime victims rights, right? Dealing with a similar subject matter, passed the same time, using similar kind of language, similar kind of concepts. So we can look at that as evidence of what Congress was trying to do, right? So this is all looking to original language, original interpretation, right? We're not even going beyond the text. We're not even going outside text to look to intent. We're looking to the pure text of the thing and looking at what did Congress actually write. So it's even textualist friendly, which is nice for me. So you don't even have to look to try what they're doing. You can look at the plain text. They use these language here, this language here. They pass at the same time. They must mean different things, right? So okay, makes sense. I buy this. This is pretty good analysis here. Together, the textual and these textual and contextual, considerations lead us to conclude that on balance, CVRA is best interpreted as applying only to the commencement after the commencement. Although not precisely on point, we find resonance with the Supreme Court, what they said in Lagos versus the United States, which concerned another federal victims' rights statute, the Mandatory Victims Restitution Act. Again, similar kind of statute, similar kind of purpose, so it's not exactly on point, but, it's something. It's something more than nothing, right? Aren't all judge textualists? No. Yeah. Robert, you're welcome. I'm happy to do it. In particular, the court addressed the portion of the statute requiring reimbursement of expenses crime victims incurred during the participation in investigation or prosecution. The question before the court is whether the provision should be interpreted narrowly to require reimbursement only of those expenses incurred during government investigation and criminal proceedings, or more broadly to include any investigation, any proceedings. The court unanimously adopted the narrower ruling. In doing so, the court readily acknowledged there are contrary arguments favoring the broad interpretation. In particular, the more limited reading will sometimes leave a victim without restitution remedy sufficient to cover some offenses and thereby contravene the purpose. The court further conceded that while it thought the statute's individual words suggested a more limited interpretation, they did not demand it. Even so, the court held understood its context. For instance, the fact that the terms investigation proceedings were both linked to the word prosecution, the more limited reading was preferable from a textual and structural standpoint. These are good arguments. I like this. Yeah. The court concluded its interpretive analysis this way. Given the differences between the Mandatory Victims Restitution Act and other restitution statutes, we conclude the considerations we have mentioned, particularly those based on reading as a whole, tip the balance in favor of a more limited interpretation. And just so here. In light of CVRA's text overarching focus, we too conclude the interpretive balance favors a more limited reading. Yeah. This argument's pretty sound. This argument's pretty sound. I can't find major fault with it. I can't find major fault with it, and some of the points that I thought were a little weak are being strengthened by other points. So it's like, yeah, this is a pretty good argument. There's a final consideration too, and it's weighty, in our minds it's weighty. The CVRA's final substantive provision, which Congress slid in just before statutory divisions and closing directive, states that nothing in this chapter shall be construed to impair the prosecutorial discretion of the Attorney General or any other officer. I don't know that necessarily, like, this isn't an issue necessarily of discretion. Like, that is, I feel like it's a little bit off, and maybe the court will convince me of this too. But, like, the issue as to whether or not the prosecutor can do what he likes, it's not quite the same as thinking that we have to bring the victim in on the loop. Like, we actually have to face them in the eye and, like, say why. Like, the victim may not be able to do anything about it, because we have discretion to not bring charges or a whole bunch of stuff, but, like, we have to, like, at least hear them out, right? So, like, the victim's rights are somewhat narrow, but they're still existent, would be what I say, right? The prosecution has the right to bring the cases that he likes. He has the right to bring the charges he likes. He has the right to reach the deal he likes, and the victim can't stop him. But, the fact that they have to at least consult with you and explain why they're going to ignore you, is not quite on point. But we'll see if the court can convince me of this. Broadly defined, the term prosecutorial discussion refers to soup to nuts entirely of the prosecution's power to choose from the options available in a criminal case, such as filing charges, prosecuting, not prosecuting, plea bargaining, and recommending a sentence. The core of prosecutorial discretion, though, in its essence, is the decision whether or not to charge in the first place. Fair enough. The Supreme Court has repeatedly affirmed the principle, which dates back centuries, that the executive branch has exclusive authority and absolute discretion to decide whether or not to prosecute. Fair enough. Fair enough. We believe the petitioner's interpretation of the statute risks impairing the discretion in two fundamental ways. As an initial matter, consider the very first determination a court must make when asked to enforce whether a party seeking benefit as a crime victim. The reason is because the opening provision makes clear that acts of protection are only available to crime victims. Noticeably, for our purposes, the statute defines crime victim to mean a person directly and proximately harmed as a result of the offense. Accordingly, any movement asserting rights must at the very outset determine the district court that they're a crime victim. And given the statutory definition terms, in order to determine whether a movement has made a requisite showing, the court must determine whether a federal offense has occurred. Interesting. When a prosecutor has already commenced criminal proceedings against an identifiable for a specific crime, they may presumptive determination that they've committed a federal offense. So as applied to the post-charge, in the context of ongoing, the crime victim determination is straightforward. An individual has been directly and approximately harmed, as a result, is entitled to these protections. Not so before the commencement. In that circumstance, if the movement were to assert rights as a crime victim, the court would first have to determine, but this time without any initial determination by the government in form of a charging decision, indeed, presumably while the government's investigation is ongoing, whether or not a federal offense has been committed. That's a fair point. That is a fair point. That is a very fair, it's a very technical point, but it's a fair point. That scenario, which necessarily consequent of the interpretation, presents at least three intractable problems. First, and most obviously, petitioner's reading puts the cart before the horse. When else, if ever, the courts decide on whether offense has occurred as opposed to a moral wrong before the government has ever decided to press charges? The answer so far as where is never. Fair enough. Second, in the absence of a charging decision, will the government even go about ascertaining whether an offense has occurred? What would that proceeding look like? A mini, or perhaps not so mini trial, in which the court makes findings and legal determinations regarding the offense yet to be named? That's fair. Finally, in any event, it seems obvious to us that simply by conducting such a proceeding and concluding upfront that an offense has or has not occurred, the court would not only exert enormous pressure on the government's charging decisions, but likely impair the government's ongoing investigation. The impairment of prosecutorial discretion, we think, would become palpable. All right, fair enough. It's fair enough. It's persuasive reasoning to me. I don't like it, but a good judge should be able to reach decisions they don't like, and I think it's not a decision I like, and it's pretty on point. Second, even if threshold crime victim barrier could be overcome, the enforcement of the pre-charge phase will risk unduly impairing discretion. Consider as a matter how the CVRA enforcement occurs. If, for example, an individual claiming to be a victim believes, as petitioner did, the government hasn't conferred with them in the manner or treated them with fairness, they'll ask the district court or the prosecutor to confer and treat them fairly. Even in the post-charge phase, those are pretty extraordinary requests. It's no small thing to ask a judge to enter an injunction or the government's lawyers, presumably on pain of contempt, to conduct their prosecution in a particular manner, but at least after the commencement of criminal proceedings, and accordingly after the government has submitted itself in a case to the court's supervision, CVRA explicitly authorizes the intervention. Congress has made the determination the intrusion was necessary and appropriate. Before the commencement of these proceedings, though, the intrusion would be significantly greater, both quantitatively and qualitatively. This is a qualitative matter, petitioner's interpretation, pursuant to which the CVRA's protections would extend in detection and investigation phase, risks greatly multiplying the sheer number of opportunities for judicial intervention. That is a fine point. And always in law, you do worry about the limiting principles, or at least I do, right? You always worry about what your limiting principles are. It's like, if you're doing this, what's stopping you from going further, right? It's one of the things you have to worry about, particularly if you're more conservative leaning, right? Myself, you always worry about downstream consequences. So, like, if you're going to do this, like, where is the logical line stopping, and why is it there as opposed to somewhere else? And there's nothing really in statute to pin you down, right? If it applies pre-charge, then where does it stop? And why does it stop there? And there's no point beyond, there's no logical reason to put it anywhere else that I can immediately see. It's something where it's like, the statute, if it applies pre, seems to apply everywhere pre, and it does raise a whole host of problems. So, like, I think the parade of horribles, or slippery slope, or whatever you want to call it, to me is a fairly valid line of reasoning in judicial reasoning, because you do have to be concerned with what happens next. Judges always have to be concerned with what happens next. It's the only way to ensure justice. And so the court is asking, well, what happens next? And they can't see the end. And that is a problem. That's a problem I'm sympathetic to, so I understand this. Yeah. Freed from any line limiting the act's applicability to the post-charge phase, courts be empowered to issue injunctions requiring consultation with victims before raids, applications, arrests, witness interviews, lineups, and interrogations. That would be an extraordinary expansion of already extraordinary statute. That's a fair point. The intrusion occasioned by the pre-charge interpretation would also be qualitatively different. The commencement of criminal proceedings marks a sensible boundary on the prosecutorial discretion spectrum. It's a clear line. That makes sense. As already explained, before charges are filed, when the government is still in the process of investigating, the authority and discretion are understood to be exclusive and absolute. By contrast, once the charge decision is made, the prosecutor steps into the court's jurisdiction. That's right. So before the charge is raised, it's wholly within the executive branch. Once the charge is filed, now it's in a joint status with the executive and judicial. So that makes sense. I understand this. From that point forward, the court will serve a more active role in administering adjudication of guilt and determining appropriate sentence. Intervening the CVRA to apply post-charge, as terms plainly permit, squares with this background of a judicial involvement. It makes sense that you might ask a judge to reopen a plea deal or reopen a sentence or things like that, right? Because, like, the prosecutor can or the defendant can, and you might be able to. So that makes sense, like, after this case started. But before, it's, the logic of this is pretty good. Implying the act to apply pre-charge contravenes the background expectation of executive exclusivity. Separation of powers. Yeah, that makes sense. Like, Congress might be able to change this, but they didn't do so explicitly enough. Yeah. I'm not happy about it. I'm not happy about it because, I think the whole Epstein thing is completely absurd. And I think that something other than what it purports to be is going on. I don't think Epstein was just a financier who, had some very questionable habits and committed suicide in prison. I don't buy it. Something else is going on here. What that something else is, I don't know, but there's something else going on. Whether or not he was an intelligence operative actually sounds pretty good. Or not necessarily operative. Let's say asset is probably better, because operative implies too much. But an asset of some intelligence agency somewhere seems pretty likely. I mean, if you look at what happened, you look at everything, you look at the things, you look at, like, the lack of records that exist and all the rest of it, the idea he's an intelligence asset of some government somewhere seems pretty plausible. Like, where does money come from? Where are the trading records? Where is all that stuff? It doesn't seem to exist. Why did the head of Victoria's Secret give him his house? And like, where's the stuff coming from? Nothing makes sense. And, it's all pretty weird. It's all pretty weird. It's all pretty weird. For reasons we've explained, we conclude the statute is best understood in terms of terms and conditions which is enacted to apply only after the initiation of criminal proceedings. Should I change? I guess technically I could change the title, but I'm not gonna. I'm happy. Yeah, that's close. It creates the right sentiment. Plus, what am I doing? Defaming Jeffrey Epstein? Come after me, right? Lord. To the extent the Act, statute, language, and structure leave any doubt as to its proper scope, we must assume Congress acted in the background of long-settled understanding about independence with regard to charging discretions. How Congress intended to upend rather than reinforce that, we can only assume they've expressed it more clearly. It's fair. For the foregoing reasons, we hold the statute does not apply before the commencement, and thus in this fact is not given it a judicially enforceable right. Yeah, we were having that debate about whether or not you can defame someone legally who's dead or not. I don't know, nor do I at this particular point do I care. I don't. It doesn't matter. Having so held, two final words. First, regarding the dissent. Although we've endeavored along the way to meet a few of the dissent's specific critiques, we must offer here two more global responses. As an initial matter, with respect to the dissent's charge that we've dressed up what it calls a flawed statutory analysis with rhetorical flourishes, while readers can judge for themselves whose rhetoric is in fact more florid. Cute. More substantively, it remains unclear to us exactly how the dissent thinks the CVRA should be interpreted and applied. It's obvious that our dissenting colleague doesn't particularly like our reading, namely that CVRA rights don't attach before the initiation, which is fine, as well as we've already confessed we don't particularly like it either. But she offers no intelligible alternative. At times, the dissent suggests broadly, but without elaboration, the statute should be applied pre-charge. To which my question is when, how, and so is the majority's question: when, how, what are the limitations? It's like, it's a real problem. That reading, while we think wrong, at least has the benefit of coherence and clarity, but the dissent, we think wisely, doesn't seem eager to defend so sweeping an interpretation, perhaps because there's no logical stopping point. It is a problem. Instead, the dissent hence, although again without any real explanation, CVRA should be understood to apply only, or at least, once the criminal case has matured in plea negotiations. Where, though, as our defense colleague would say, in the holy name of plain text, does that limitation criterion come from? Yeah. As best we can tell, is derived specifically to capture this case without risking a landslide. Yeah, we're making it up as we go along. That's not really something we're supposed to do. For reasons we have explained in detail, we believe that the CVRA is most properly, if imperfectly read, to apply only after the commencement of proceedings. One thing of which we're certain, that interpretation is far superior to the sense good for this train only, once the investigation is mature reading, which as far as we can tell, has no meaningful footing in the structure. Yeah, it's a problem. It is a problem, yeah. Second, and far more importantly, regarding the consequences of our interpretation, it isn't lost on us that our decision leaves petitioners, others like her, largely empty-handed, and we sincerely regret that. Under our reading, the CVRA will not prevent federal prosecutors from negotiating secret plea and non-prosecution agreements without notifying victims, provided that they do so before instituting proceedings. We can only hope, in the light of protections provided by other statutes, and even more so in the wake of public outcry, that they won't do so. The question before us isn't whether prosecutors should consult with petitioner before negotiating. It seems obvious to us, indeed the government has expressly conceded they should have. Our sole charge is to determine on the facts whether obligated. We simply say that they did not, petition denied. Yeah, that's, and we have a concurring opinion here. How long is this concurring opinion? It's not that long. I'll read it. I concur without reservation in Judge Newsom's opinion for the court. I write separately because the model of the dissent creates, in which a victim is permitted to sue the U.S. attorney for refusing to confer about a criminal manner prior to indictment would in operation result in the judicial branch's interference with the executive branch function of investigating and prosecuting federal crimes. Such a model raises serious questions about whether by doing so the judiciary would be violating separation of powers. That too. That too. Yeah. There can be no doubt executive branch has exclusive power over prosecutorial discretions. This executive branch authority obviously includes decision to investigate suspected criminal activity and whether to seek or not to seek indictment from the grand jury. These pre-charge decisions are the focus of this case. The dissent interprets the statute as authorizing the victim to bring U.S. attorney to court for refusal to confer with her about a matter of criminal investigation. To illustrate what would likely occur if permitted the victim to do that, to envision how dissent's interpretation would operate, consider a simple case of mail fraud. Yeah, illustration by example. I understand this. Jane, this is hypothetical now. We're talking about a hypothetical case to illustrate a point, right? All right, fine. Jane Doe is the victim of a fraudulent scheme. She finds out that the U.S. Attorney's Office is investigating the scheme and wants to discuss it with the attorney handling the investigation. The attorney refuses her request, so she sues him. Applying the dissent's interpretation, the district court finds the attorney violated the statute by referring to confer. The court issues an injunction requiring them to confer and treat her fairly. Even if the court could craft such an injunction to comply with the rules of federal procedure, which I doubt, the court would then be continually involved in the criminal investigation from the moment it issued the injunction. Yeah, ongoing duty to see. Yeah, that is enforced. At any moment during the inevitable twists and turns of the pre-indictment criminal investigation, the victim could allege the attorney violated the injunction. The attorney would be back in front of the district court to show why they should not be held in contempt. But the event most likely to trigger such a hearing is the decision not to take the case to the grand jury, and that decision is complete within the case of discretion. Therefore, applying dissent's interpretation will clearly interfere with executive branch investigative and prosecutorial functions. Excuse me. There we go. Having explored the consequences of dissent's interpretation of CVRA, it's clear that such an interpretation cannot be accepted. The notion that a district court could have any input on the U.S. Attorney's investigation decision whether to bring a case to a grand jury is entirely incompatible with constitutional assignment to the executive branch of exclusive power over prosecutorial decisions. Additionally, it's hard to imagine a bigger intrusion on executive autonomy than the possibility the U.S. Attorney will be held in contempt for violating the injunction if the investigation is not handled as the victim and district court sees fit. Therefore, a district court raises serious constitutional issues by concluding there are no temporal limitations on the right to be treated fairly by the U.S. Attorney. Fair enough. Yeah. In contrast, under Judge Newsom's interpretation, the problem does not exist because the statute only gives victim post-charge rights. And post-charge, the district court is not dragging the U.S. Attorney into court against his will and imposing condition upon prosecutorial discretion. The attorney is voluntarily before the court, and it's appropriate for the court in its active role in the criminal proceedings to examine the attorney's failure to comply with the statute's obligation. In such circumstances, no concern about separation of powers because the court is not meddling in the executive branch decisions until executive branch officers have chosen to present themselves in court. In sum, the dissent's interpretation creates serious constitutional concerns that this interpretation is not, and settled policy that when presented with two interpretations, we should avoid the interpretation that creates constitutional issues. Fair enough. Zachariah, is there anything stopping Congress from reading this and saying that's not what they meant? There might be some limitations on that as it relates to separation of powers, but in the broadest sense, no. I mean, they can definitely fashion remedies around this. So there might be some limits somewhere, but I don't think that there's anything really barring the legislature from doing a lot of things in response to this. There's probably a limit though somewhere, but yeah. Judge Nelson's interpretation should be adopted. The conclusion is bolstered by the language of statute, which expressly states that none of the provisions should be read to diminish the discretion. Clearly, the author of the statute, Congress, recognized the need to avoid any construction that results in the problem the sentence approach creates. For all the reasons, the CVRA is best understood as not applying until the charges are read against the defendant. Fair enough, man. Fair enough. And then, so that was 60 pages. That was 60 pages. And then the dissent goes on for 16 more pages. But I don't have the energy to read 60 more pages. And I think that we have understood the majority's point, and without reading the dissent's point, which might also convince me, of course, but without reading the dissent's point, I understand the limiting problem. The limiting problem is always a problem to me. This is something I naturally respond to, especially as a judge, right? Congress can do broadly what it likes, but as a judge, you're looking for limiting principles because you want things to stay in boxes. You want things to be constrained. And so you say, well, the line is the creation of the indictment. The line is the creation of the information. The line is that's the line because it's clear, delineated, understood, seem clear by the statute. If we want to abolish that line, what other line are we going to do? It's like, can we do it just for this time only? Not really. We can't really do that, right? So, makes sense. Yeah. Jan, what are you doing? Jan, I had hidden that guy. Don't don't undermine my moderation decisions, please. Thank you. Yeah. No, Jan, I had already hidden him. I had already made the decision. I'm the owner of the channel. You don't overrule my decisions, Jan. Thank you. Appreciate it. If you like this decision, if you like this channel, if you like this stream, I would appreciate that you give it a like. As always, I'm happy to be doing this for you. I hope you found it educational and informative. I certainly did, but it really made me really was interesting, really informative. It really made me think, which I appreciate in the judicial decision. Made me like um, really made me think about it. And on balance, I think the majority makes a really compelling case. Maybe on a different day, I'll get to the dissents half of the case, and we'll cover that too. But I really, really think that this is pretty persuasive and understandable. So it's like it's pretty good. So yeah. So all things being considered, I think it's good. I'm glad you were here for me. Until later, my friends. Hope it's all is well. Until later. Cheers and goodbye.